So we have really two presentations. When we looked at the file, we realized there was one regarding the home sale and there was a cleanup one that had never been entered from May. So I'll address the home sale one first. There should be an order regarding home sale. Ms. Gibson filed objections. The only thing she's really objecting to is I'm asking for the home proceeds to be placed in my trust account. She wants it to be placed in essentially a bank account with both their names on it. That's just not appropriate. It should be a significant amount of funds. Ms. Gibson's already been found in contempt for financial misconduct in this case. Second, based on material she's previously filed, there are concerns whether or not she has fraudulently altered documents, again, leading to quite a bit of concern on what she would do to access those funds. She doesn't provide any other.
A tense courtroom hearing begins as lawyers discuss two pending issues in a complicated family case. One concerns the sale of a house, while another order from a previous hearing was never officially entered. The court must now decide how the proceeds from the home sale will be handled. With significant money potentially involved, both sides are preparing to argue their positions carefully.
Basis for putting it into a sort of traditional bank account instead of an attorney's trust account for safekeeping. There's just no reason not to protect the funds, especially when we anticipate the funds will be $150,000 or more. My client just wants the funds protected and have them placed in my trust account. So we're asking the court to sign the order as presented.
And when were those objections filed? Because I didn't see any objections.
Yeah, I can find it. Looks like she filed July 6th. It's Clerk's Papers 223, if that helps.
Their objection to proposed orders. Thank you.
Yes.
Okay. And I guess I did review that. Miss Gibson, any response there?
Yes, Your Honor.
The petitioner's attorney explains that the only objection from Ms. Gibson is about where the house sale money should go. The lawyer insists the funds must be placed in an attorney's trust account for safety. According to the attorney, a regular joint bank account would be risky given the history of financial disputes in the case.
Putting them in a joint account gives equal access to both parties. You had previously ruled, because I'd also asked at that hearing where the court had decided for the home to be sold, that each party be allowed access to some of those funds, particularly because I will need access to some of the funds in order to move. And you said that you would reserve and consider that at the time when the home sells. I need access to those funds. Ms. Baldwin's accusation that I've documented or falsified financial records just isn't true. And it's also really easy to see if there's a joint account, if money's taken out, which person takes it out, where it comes out of. So there's no risk of.
The lawyer also reminds the court that Ms. Gibson has previously been found in contempt for financial misconduct. That history raises serious concerns about how the money might be handled if she had direct access to it. With the home expected to sell for more than $150,000, the attorney argues the safest option is strict protection through a trust account.
Money being moved without the parties being aware of it. And because you made that ruling that you would decide or that you would be willing to allocate some of those proceeds, it just makes sense to put them in a joint account. It can accrue interest during that time. Both parties can see where the money is, so that I can just know that if the court does make a ruling that I am allowed access to those funds, that I can get immediate access to those, that I'm not trying to have to work through Ms. Baldwin's office, which whatever delay that may or may not incur, that I have funds available should the court allocate those to each party. So that's my only concern. And I guess just a clarification point, I don't know if it needed to be in the presentation order, that when the realtor comes out, if there are any costs to
When the judge asks about the objection, Ms. Gibson responds directly. She argues that placing the funds in a joint bank account would give both parties equal visibility and access. In her view, transparency is the best protection because any withdrawal would be clearly documented.
Any sort of, not upgrades, but any sort of costs incurring to getting the home ready to sell, that those be split equally among the parties, that I shouldn't be solely responsible for those, as petitioner is still on the mortgages for the house, and they are the party that wanted the home sold and not myself.
Okay. Let me start, and then I'll turn to you, Ms. Baldwin. So I guess as to the trust account, there are very, 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 very strict guidelines on attorneys' trust accounts. And frankly, the historical posture of this case, I think the trust account is the appropriate place for the funds. If there is an allocation of funds, which I did reserve and said I would be willing to consider to allocate funds, there should not be a significant delay because it's in a trust account versus a joint account.
Ms. Gibson also explains that she may need access to the money after the house is sold. She says the court previously mentioned the possibility of allocating some of those funds to each party. Having the money in a joint account, she claims, would prevent delays if she needs the funds quickly.
There was, I believe, a contempt that was found previously for on a respondent for essentially doing the thing that you're claiming you're worried about happening to you. So I am not swayed by that argument. So I think the trust account is appropriate. As to any, and I appreciate Ms. Gibson raising this issue because I don't know if that was brought up. So if there is, something that needs to be done to the house in order to approve it for sale, I don't know that we address that. So Ms. Baldwin, whenever you're ready.
So on that issue, that really hasn't been raised in any declarations previously or any motions previously. Generally, because we do have a selected real estate agent, that agent will go through the home, make recommendations on what's possible, what's feasible, what's financially prudent, and then usually the parties work.
Another issue quickly surfaces in the courtroom. Ms. Gibson raises concerns about potential costs needed to prepare the home for sale. If repairs or improvements are required before listing the property, she wants the court to confirm that those expenses will be shared equally between both parties.
That out. So it's to both of their benefits to maximize the sale price. I'm not saying my client won't contribute, but the contempt that we have coming up next indicates my client doesn't have a lot of funds to do that with. And so I just don't think the court should address it. I have Ms. Evald's information. She readily communicates with me if there's some kind of repair or sort of curbside improvement, beautification. We can certainly talk about that. I just don't think it's properly before the court. So again, both parties are motivated to deal with improvements. Usually then the way we handle that is after the fact. Everybody provides receipts and that gets paid off the top. So I don't have any objections to those sorts of things. But again, those all need to be agreed on, things that Mrs. Evald recommends. And so I don't think the court should address it today. I just don't think that we're...
The judge begins to weigh the arguments carefully. After considering the case history and previous contempt findings, the judge explains that attorney trust accounts operate under strict rules. Because of that oversight, the court believes the trust account is the most appropriate place for the funds.
I don't think it's necessary. It's not properly before the court. It's something that I haven't historically had a problem handling when both parties are motivated to maximize the sale price.
So at this point, it sounds like there's a commitment to trying to work things out. If there are any bills or anything that, if there's a water heater on its last legs that needs to be replaced, whatever it is that's suggested, or if something comes back from a home inspection that, I think that can all be negotiated either outside of the court's purview or in front of the court if it comes to that. But my hope would be that the parties would be able to work together on those issues. So I am going to sign the order regarding home sale as it's presented. Then I have the order.
The judge then turns to the question of home repairs. While acknowledging Ms. Gibson's concern, the court suggests these issues are typically resolved between the parties and the real estate agent. The focus should remain on maximizing the home's sale price for both sides.
On hearing from May 30th. Ms. Baldwin?
Yes, we did provide that. I'll note we didn't provide a full week's notice on that. If Ms. Gibson is requesting additional time, that's fine. I think this was intended to be presented at a prior hearing, but we had some intervening surprise things happen, and so this sort of fell by the wayside. So I haven't received any objections to date, but she's had less than the full week.
Ms. Gibson, do you want to, are you prepared to deal with this today, or would you like more time to review the proposed order for on hearing from May 30th?
I would appreciate some more time. I was confused when I received it, what it was regarding or what it was about.
The petitioner's attorney agrees with the judge's approach. She explains that once a real estate agent evaluates the property, recommendations for repairs will be made. Usually, both parties cooperate because improving the home's condition ultimately benefits everyone involved in the sale.
I'm not sure how to address it because I didn't know what it was in reference to.
Okay. Do you, is 2 weeks enough time for everyone?
That's fine.
Does that work for you,
Okay.
Ms. Gibson?
Yes.
Okay, so I'll set over the order on hearing for May 30th to 8/1/23 at 1 p.m. And I made a note, Ms. Baldwin, on your original order in hopes the clerks will hang on to it for that 2-week period. Okay, and is there another issue that we need to address?
Yes, we're also before the court on contempt.
If I may, before you begin, Ms. Baldwin,
Go ahead.
for the court. So I have been in the process for a while now of trying to obtain counsel.
With the discussion complete, the judge makes the first decision of the hearing. The order regarding the home sale will be signed as presented. The proceeds will be placed in the attorney's trust account until the court later decides how the money should be divided.
I had a scheduled consultation appointment with counsel that got unexpectedly rescheduled due to an illness. I had hoped to have representation for this hearing. I am set to meet with counsel later this week. So I would request, since we just set a matter over for 2 weeks, to set this over, because I was prepared to have representation for this hearing today that, as I said, got rescheduled due to an unexpected illness. It's been very difficult, as I'm sure counsel and the courts are aware of, trying to get consultations with attorneys in family law matters.
I can't disagree with that. I'm sure appointments are difficult to come by. Ms. Baldwin, any objection to setting the contempt to 8/1?
Certainly do. Here's why. The contempt was originally scheduled for last week.
But the hearing is far from over. The courtroom shifts to a far more serious issue, a contempt motion. The petitioner's attorney accuses Ms. Gibson of failing to pay her portion of daycare expenses required under the child support order.
Everyone understood that we were going to have that heard last week. That's why we put, if the court will recall, there was a restraining order. We put the restraining order on the same date because as the contempt filing, because that was already sitting last week before the court. And I said I didn't care what judicial officer heard it, and Ms. Gibson said I want to heard it as soon as possible. So last week we come before the court. Ms. Gibson then, despite having filed a response, basically says, well, I don't want it heard. Makes no mention of finding counsel, kicks it over to this week at her request for continuance. Here we are yet again. Again, she's filed her response. Nothing has really changed. Counsel may come in or may not come in. We don't know. But the reality is we're in a position where we've already had, this is the second hearing where we've come before the court on the contempt. Everything's filed. I think it's appropriate that my client receive relief. The children at this point are suffering very real consequences.
According to the attorney, Ms. Gibson previously assured the court she could afford her financial obligations. She even claimed she could refinance the house to prevent it from being sold. Now, however, she says she cannot afford the required daycare payments.